नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां आज हम आपके लिए लेकर आए हैं एक नया लेसन।
What we were discussing, what all you understood till now in the Companies Act, company law, I will say. Isha is there. ना बुलाते ही मीटिंग लेफ्ट भी कर रहे हैं, बताओ। Ritu is there.
Yes, ma'am. Good afternoon.
Good afternoon. बताओ क्या क्या हमने अभी तक डिस्कस किया, कुछ आइडिया है?
Ma'am, out of the classes that I attended, I studied about the Companies Act,
हाँ.
then types of companies, one-person company, then other types of companies.
Okay. Good.
How about that?
ठीक है. Okay. Then Ananya.
Yes, ma'am. Ma'am, yeah, we discussed some of the sections of the Company Act. I'll just tell you what we were doing last class. So we were doing Suleiman versus Suleiman Limited, and we discussed the theory of corporate personality, legal personality. We did Jering's theory, how a legal person is a real personality, and how a company is a social organism.
Yes.
And we were supposed to discuss that even further, and we were supposed to discuss the facts of this case.
Yes, very good. So just I know I wanted to know now if somebody is if even one student is replying, then that's good for me, so that at least I will come to know that yes, somebody is listening to me. Otherwise I feel I don't know who is listening, or just for the attendance coming, then joining, then going, coming back. Yes. So we were today in detail. We will again discuss the Salomon's case. That is part of one of the important aspect of one-person company, or the theories of corporate personality, which we have discussed. And this Salomon's case signifies the three perspective of it. One, in this case, it discussed about the the concept of agency principle, trust relationship, and then whether an artificial entity or an artificial creativity is a legally recognized part of legislature. So this aspect has been discussed. So let me try to screen share with you the case of Solomon. Is it visible? It's visible, na? दिख रहे हैं ना आपको? Yes. So this is the case of 1897. ठीक है, आप देखो यहाँ पे हाउस ऑफ लॉर्ड्स में डिसीजन लेने के लिए it has not taken many years. So the company was formed in 1982. And remember that in this, Aaron Solomon, he had some 30 years, that is priorly before 1892, he used to have the shoe manufacturing business. It was going on very well. Okay, I will try to, before I show you this, I will just try to show you a small video clip. Okay, though this is again a Google aspect, but still let us try that also. Just a small Google दिख रहा है ना वीडियो? So let me try to इसमें ना आवाज तो नहीं आ रही है इसमें. So you can see the Solomon case. So he was running a shoe business under the name of Solomon. And see who all are there. The Companies Act was 1862. There were subscribers: Solomon, his wife, daughter, and 4 sons. And Solomon himself was having the shares. Then later on, the company went into insolvent. And this is what the company, the decision, that is, once the company is legally incorporated, it is independent person. So if we go to this is more, again, as I told you, it's only, I will show now. I will again come back to the case. Okay, now, so what was it? He was a very a good businessman, having very prospered business 30 years prior to 1892. That's very important, क्योंकि 1892 में उन्होंने अपना कंपनी फॉर्म की थी. He under the style of Solomon and Company, A. Solomon and Company. So his full name is Aaron Solomon. Aaron Solomon had 30 years. He has come up with this company, and this company was formed in 1892 in order to carry the business of shoe manufacturing and exporting it. And who are all the subscribers to the Memorandum of Association? So this Memorandum of Association is an important document that is part of formation of a company. And in this, the appellant, that means Solomon, his wife, daughter, and his 4 sons, they were the parties, they were the shareholders of the company. And the nominal capital of the company was 40,000. And it was divided into the shares according to whatever the schedule has given. And the board of directors consisted of himself and his 2 sons. So the board of directors are also a kind of family, that is himself, Solomon, and his 2 sons. And others, wife and other sons, were the shareholders. So 7 shareholders of the company, which is mandatory or which is required. And the directors are also his sons and himself. And then they resolved to pay the appellant. Appellant here, it means the Solomon. Solomon, they decided to pay because he has transferred, he has sold his business to the company. And for that, he was given 10,000 debentures and 6,000 rupees cash. And these debentures were actually, they were the secured debentures. That's what the secured, it was secured. And what happened? Unfortunately, the company went into liquidation. And at the time of liquidation, there were unsecured creditors. They were, indebted. The company was indebted to the unsecured creditors, other than the Solomon. So what happened? The liquidator of the company brought an action against the Solomon and said that he need to pay. He need to pay to the unsecured creditors. So in a way, we can say that an action or a suit was filed against the shareholders of the company to pay the outstanding debts of the company. So if you say that the unsecured creditors have given or invested the money in the Solomon and Company Limited, it is not that they have given it to the Solomon. So the company need to be liable, right? But here the lower courts and even the Court of Appeal also confirmed it. They said that the liquidator of the company who was appointed, he said that action against the shareholders, because it is the Solomon, he himself has did all these things. So he need to pay to the unsecured creditors. So instead of taking action against the company, since it is he himself and his sons who are involved, he is liable to pay to the unsecured creditors for the outstanding money that is due to them from the company. And now this matter has been challenged before the House of Lords. So the issue in this case was, or what was the important question is that whether the respondent company was a company at all, whether Salomon and Company is a company, or if so, whether it is an artificial creation of the legislature and it has been validly constituted. So if it is an artificial creation and whether it is made with the proper or validly it is constituted. So for that, we have to look into the statute itself. That means if the statute is incorrect, or if the statute is not if the statute is if the statute cannot be accepted, or we can say that now every legislation we used to challenge, it is unconstitutional like that. So whether it is a kind of unconstitutional, and whether do you think that even in now also in the Companies Act there is some provision that your relatives or your wife, children cannot be the shareholders in the company which you have registered? Do you think, is there any provision under it? Is there any provision under the Companies Act? Yes.
No, ma'am.
No. Very good. So that means there is no provision under the legislation that creates a bar on not issuing the shares or making the shareholders or even the board of directors as part of the company. Though now we have got the concept of the so-called independent directors, now the concept has been brought in 2013. Still, there is no bar of issuing shares to your spouse or to your children. So that's what they have looked into in this case. And then again, I think the presentation has disconnected, no? Yes. So what they said, so the issue was this. And in this case, if you see, there were 7 living persons, है ना, 7 लोग थे जो living persons थे, who held the shares in the company. And this is again, if we see the English Act, English legislation, it has not barred anybody or denied it that this person should not be related. So what is the other aspect is that the relation to the company, if we come to the relation to the company, the relationship is that the law would sanction would be that they are the corporators of the corporate body. So Solomon and his family became the corporators. They are the corporators of the corporate body because it's a corporate body. It's a legal entity that has been created under the statute, under the English statute. And they have gone through all the formalities that is required. So it seems that it is impossible to dispute that once the company is legally incorporated, then it must be treated like any other independent person with the rights and liabilities appropriate to itself. And the motives of those who took part in the promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. So that means it is not required to discuss those rights and liabilities, because what was their intention? Now there is no point in looking into whether the Solomon, with an intention to defraud the creditors, he has incorporated a company. है ना? ऐसे इसने क्या is that he made this company because within the 1 year of the inspection, the company faced the liquidation and winding up proceedings. So was the purpose of constituting the company was to defraud the creditors. So the court here also said that, and in this type of things, especially the economic crimes, the intention is immaterial. The motives are not at all seen. Your intention, your motives are not seen. Your commission of offense is only thing that is seen. So, and the court also note in this perspective that he was having the prosperity. His business was going on well. He was doing his business and he was making the profit. So why he should defraud? Why he should form the company, right? So the court consider this. Then another relevant paragraph in this case comes is that, see, that's what as one mode of testing the proposition, it would be pertinent to ask whether 2 or 3, and indeed all 7, will constitute the whole of shareholders. So it should be noted that even if you have only one single share in a company, you are treated as a shareholder, even if you have a one single share. So number of shares is immaterial. Then they must be all independent of each other in the sense of each having an independent beneficial interest. This is the question that cannot be answered. Okay, and the legislature never intended to prohibit something. So if the legislature is not intending to prohibit something, then how a judiciary or how a judge can say or can impute and can say that no, it should be limited, it should not be done. Hence, the appellate court, that is the House of Lords, has struck down the Court of Appeal and the lower court decision, which made the Salomon, or which, and how they have arrived at the decision. They said that Salomon was an agent. That's how they were describing. Salomon is a trustee, or he has an agency. So agency type of relationship is there. So as an agent of the company, he should pay the company's debt. So the unsecured creditors need to be paid. Unsecured creditors need to be paid by whom? The Salomon. This is the way the Court of Appeal has agreed with the High Court, which says that Salomon is responsible to pay. That's why the Salomon appealed before the House of Lords. So, but House of Lords has not accepted the argument or the basis of the agency and the trustee relationship. Instead, they came up with a separate theory. That means it says that it is the company is having a separate legal existence, and Salomon is a shareholder. He is a shareholder, and though others are also his family members, they all constituted the shareholders of the company and the statute, and they have registered or incorporated as per the statute, and they have followed all the rules and regulations, and hence it is a creation of statutory or legal entity or legality through the legal process. And nobody can say that they should pay, or the Salomon need to pay to the unsecured creditors. And the company is bound to pay to the Salomon because Salomon happened to be the secured creditor. So the relationship of Salomon to the company, one as a shareholder and other as a debenture holder, is different. So as a debenture holder, company is bound to pay to him prior to the unsecured creditors. So that's what the court has House of Lords has discussed. And then you can see in this paragraph again, the transfer was to be made by him. One of its conditions that the part payment he was to receive 10,000 in debentures of the company. So the memorandum of association was executed by the appellant, his wife, a daughter, 4 sons, each of them subscribing to 1 share. So the memorandum of association has also been registered. It has been properly registered, incorporated under the name of Salomon and Company. So there is no question at the time of registration itself, the debentures were shown. And as an unsecured creditors, they would have seen into it. And if they have not seen, then it's their mistake, right? So similarly, coming to the next part of importance, it says that the evidence shows that before it's transferred to the new company, I told you more than 30 years he has been doing this business, and the evidence that was before the court shown that he has transferred to the new company the business which was in prosperity, and he used to get the annual profit to maintain himself and the family, and always it added to his capital. So if the liquidator, because the liquidator said that when the price was more when he has given it to the company, but if you see that at the time of transacting with the company as an unsecured creditors, you should see the status of the company. Once you have taken the shares and once you have agreed to the terms and conditions of the company, then you cannot say that. So you are aware that before transacting with them, it is consisting of his himself, his son, and the wife and daughter. But that time you never ever apprehended. But now, since it has the matter went otherwise, you are claiming it, right? So that was one of the other aspect that has been considered. Then again, you can see they are, this is the reason the incorporation of the company cannot be disputed. Nobody can, dispute the incorporation of the company, because the object of the whole arrangement is to do very thing which is the legislature intended not to be done. It has not done anything which the legislature never intended to do. And the Solomon scheme is a device to defraud creditors is cannot be accepted, because that's what they argued. These are all the arguments they have done. They said that Solomon scheme was to defraud the creditors, and then that's how he made it. But again, the court said that if it is, since the law is not prescribing anything against it, there is no question of intention can be attributed for defrauding the creditors. And the House of Lords therefore held that a company is having a separate legal entity which is distinct or independent from the corporate legal, or corporation, we can say, or a company. So the Solomon is not bound to pay, even as a shareholder or otherwise, to the unsecured creditors. And the company can only pay if there is something that is left with the company to pay to the unsecured creditors. But in this particular case, unfortunately, nothing was left to pay to the unsecured creditors. Whatever the amount that was left need to be paid to the Solomon, because he was the secured creditor. He was the debenture holder, which was again secured. And the company will not lose its identity to the majority of the shareholders. So just because it consisted of Solomon and his family members, that will not make, or that will not result in making that company a sham or a fraud company. So in this particular case, the House of Lords upheld the separate legal entity principle. So that's what regarding the Solomon versus Solomon and Company Limited. So I hope that you understood this case very well. If you have any doubts, you can ask. But now this concept, or this strong concept, is getting diluted. That's what I want to say. This concept is slowly getting diluted because of the constitution or incorporation of many fraudulent type of companies. So now, before the COVID situation arose, I have seen in the newspaper two pages ad, not ad, not report, the name of the companies, which was issued by the Ministry of Corporate Affairs and from the registrar of the companies, which said that these companies' existence are not known, the board of directors not found, then the registration, once they inquire, it is not found nowhere. So thousand, it was, you can imagine, मतलब more than दो pages में था, और इतने सारे companies का नाम I just peripherically seen. So that much of companies, and that's what the concept of vanishing company. So that is also a type of company, we can say, though it is not vanishing company. That means the company which are getting incorporated and after that it get vanished, है ना. कई बार अभी देखो कई बार वो टेक्निकल एरर की वजह से भी हो सकता है, लेकिन कुछ लोगों को मैंने नोटिस किया है, रोज उनको टेक्निकल एरर होता है, आते हैं, ज्वाइन करते हैं, फिर लेफ्ट हो जाते हैं, और जब अटेंडेंस का वक्त आ जाता है ना, तब आ जाते हैं. So that type of things happen. So in the companies also they will give the proper document, और ये सब देखे रजिस्टर्ड तो करता है, क्योंकि ऐसा नहीं कि रजिस्ट्रार ऑफिस एक एक घर में जाके ऐसे बंदा है कि नहीं है. You only rely on the documents that you have given, and after that the company will do some kind of transaction and the company will leave. And it is majorly because of to do the money laundering type of activities, and it is very difficult to track if you are doing it in the small scale. And when now we have got this concept of startup companies and all, it should be more cautious. So that is why this separate independent existence is getting diluted, not only in India but abroad. तो बहुत ज्यादा ही dilute हो गया ये concept जो है. And moreover, every time now it is suspected. पहले ही सस्पिशन होता है कि क्यों ये कंपनी फॉर्म हुई थी. अगर ये प्रूव हो जाता है कि द पर्पस ऑफ फॉर्मेशन ऑफ द कंपनी वाज टू अवॉइड द टैक्स or the company was formed with the object of tax evasion, then of course it will not get any status of independent corporate existence, and the directors or whoever associated will become jointly and severally liable to repay the debt that they have taken. So this and of course the lifting of corporate wheel, when we will explain also, we can find the situation. Yes, shell company, shell, shell, shell company. Okay, so shell companies, it's in the abroad, small companies, casinos and all this, just to evade the tax provisions and to make the laundering or money laundering aspects done. So that is why the Solomon's case, though it is still have the authority, we can say that now it is getting diluted. So the ratio of this case was that the separate legal entity has been established, and also it said that the creditors of a company cannot sue the company's shareholders to pay the company's debt. So that was also held, that they cannot sue the company shareholder to pay the company's debt. So that's regarding the Solomon's case and the related aspects relating to this. And next class we will discuss the citizen, whether the company is a citizen or not. That principle we will discuss in the next class. If you have any doubts, you can ask.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद। दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।